Good afternoon, guys. Good afternoon, Ainde. Good afternoon, Ettenbox. So we'll just start off today's session officially, and whenever other people join, they'll meet us where we are. So I don't know how many of you were around for yesterday's session. You're gonna mute your mic if you were around, or if you are not, or if you are not. Were you around at yesterday's session?
No, ma. I was around, but then I left after a few minutes, so I did not join. I was planning. I had a clashing meeting at the time, so I was planning to join today. So.
Okay, it's all right. And Ainde, were you also around yesterday?
No, I wasn't. This is my first time joining.
Okay, it's all right. Welcome to OSMG. As a brief overview, I'll just tell you what we are about. So I don't know how you came across our link, or if you're in our closed group on WhatsApp. But OSMG is a non-profit platform that is dedicated to walking the law school journey with every law school aspirant like you all here today. So the aim is for you to be able to dream of having your desired results and be able to actualize it. So that's why we're having this session. And it's not just a time where we motivate you alone. We also are practically involved in your step. However, there's a caveat, which is in as much as we're interested in your progress, you must also be sure that you are also dedicated in having that progress with us. So with that being said, I believe that why you are here is because you want to have a desired grade, be it a first class, a 2-1, but definitely not a failure. So that's yesterday. Yesterday we talked about practical steps on what you should take note of as you go on your externship. And here we had Sarah, an alumni of OSMG. She was just called about this new set. So she spoke extensively about the thing. So just because of you're not around, I'll just go through it a little before we start the station. She talked about fear and pressure, which are like recurrent issues that you as far aspirant might go through. The fear can come from, oh, how do I actually have this result? This curriculum seem bulky. Some topics I don't understand it. And pressure maybe from the time or from people that you're with, or for any other factor at all. Things are like recurrent issues. But how do you combat them now that you are on your way back to school? The first step of many steps is being honest with yourself. Okay, where am I at currently? I came back from school to college internship with the mindset of being able to go through my course outline completely for each courses. But now I'm going back to law school and I've not covered this, I've not covered that. Oh, I've been able to cover all the topics before we went on extension. Oh, I'm not able to do that. Oh, I've read new topics. I don't know where you are at now. But whatever it is, be honest with yourself. And this honesty is not a caveat for laziness. It's just a sense of, oh, this is where I am, and these are the steps I'm to take. So with that being said, what's the next thing to do? Do the best for you. Work smart. Put knowledge to practice. How do you do this? You read your books. Anytime I say read your book, and you might hear it often from any of our session, but anytime I say read your book, for me it means not just reading your book as per reading what you wrote down in your materials or in your class. It means reading a topic, actually trying to draft in the topic, and practicing your past questions. So if you're able to do this effectively, I see no reason why you're not going to get results, especially when you're doing it beautifully and you cover the field across all topics for all courses. With that being said, your mind will be able to bear the thoughts of having a desired result, because it's more than a part of that talk where I'm motivating you. No, I'm saying it because your mind is a very fundamental key factor in anything you have to achieve out of law school. If you feel like you'd pass, you would pass. If you feel like you would fail, well, you know the answer. But what more important for me is that when you feel like you're going to pass, it means that you are one step ahead of the efforts that it takes. So know that, okay, once your mind is geared towards passing, it means that invariably you know that you're supposed to put in every work, which means there will be sleepless nights. There'll be nights where when you are reading your book, you don't understand. but that's not an excuse of covering your book. You still go back to it. Then I know you have an excuse of, oh, in my court they are always making me busy. How do I manage these things? To be honest, over time it's not going to be an excuse, because law school is a very, very, very jealous lover, and it requires you to give every single thing that you can give if you want your desired results. So which means that in as much as this realities are true, yes, the time is very short. The thing is, what can you do based on that reality? A short expose will be my own experience in law school. It was very, very crazy for me from externship period, because I was living in a family house where I was not at home, so I was living in somebody's house, and then where I was, yes, they required me to they required me to do housework with my work. And when I say housework, it's not the usual one. I mean like crazy housework, and it was very bad. So at the point I was getting annoyed, but I thought that this thing, because unlike you, where your relationship is broken into it's broken into two parts. Mine was like at a stretch. So I was like, Ewa, you cannot continue like this if you want to have your desired results. Now that these areas are through, what can you do? Now that this person will stress you a lot, what can you do? So I actually had a 24-hour timetable where I wrote, okay, by this time I know I'll be sleeping. After this time, any person will be disturbing me. So when I finished everything in 24 hours, after like when I wrote my court extension and all the realities, I thought that maybe I had like 2 hours or 4 hours to myself. So I was like, okay, I can manage this. And that's what I worked with. It was crazy, it was very demanding, but what I'm saying this to say that give law school all it takes. Laziness is not an excuse. Like you do not have something, also it's not an excuse. You may say, oh, I don't have desired textbooks. I'm going to tell you that it's not an excuse, because I'm saying it from a pure experience. In terms that you have some books that you have to buy, because I know how law school books can be very expensive. I may not be able to afford them. But if you have a phone, then you have everything. And what do I mean? I don't mean that you can download material from the internet. I mean that when you are reading, and maybe for example, you need textbooks to solidify your reading, what do? Borrow your friend's book or go to the library and snap pictures of what you need and pop it to your laptop on your phone, and you'll read up. So you can say that I'm not telling you to say that okay, what you're experiencing is not true. I'm saying that you really cannot afford dwelling on excuses. So I don't know the issues you're having privately, but for law school period, I want your mind to be at its peak, at its best. And I'm not saying that you should not, maybe feel weak sometimes. That's why we are here. When you feel overwhelmed, when you feel troubled, when you're sometimes you don't understand, it's your duty to tell us so that we can help you. You get it? So another thing she said was about how you can also practice delayed gratification, which means that just like what I just finished saying, where I said you should stress yourself, that so that you're not go back at law school and have any further regrets. So if maybe your family background is very bad, you cannot really afford some things. Question is, rather than looking at the problem, what can you do to achieve the best out of the problem? Thankfully, you have this platform, but I hope you're going to be able to maximize it. As a thing of pride and a thing of encouragement for you, in fact that and in this current set, we had the BGS from this group. So what I'm trying to say that you have what you need, even if in your own speech you don't have it. From us, you can get it. So try and not possible to tap it from us. If you don't get it, there's nothing else we can do for you. So just say to end what she said yesterday was ask questions if you have worries. I think that's what I just need explaining. If you have queries, ask. If you have issues with your drafting, ask. If you have issues with retention, ask. If any issue that you have at all, bring it up. If you're on a platform on WhatsApp, that's why I'm always particular about you sending me. I always ask, how are you? It's not because I'm asking for formality's sake. I'm asking because that's the only way I can know the area that I can help you on. Because of course, I may not be able to teach you everything word for word because of my own schedule. But if you tell me what you're having issues with, I will always create time and with our team from OSMG, which means the alumni team. I can always know them that okay, please come and help out this person. But if you don't say anything, we can't do anything for you. And lastly, be disciplined with your time. Your time is very, 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 very important to you. So you must make the best of it. So with this said, I mentioned yesterday that wait, no, let me just pause here and ask if you are following. So for Etim and Etimbock and Wright, I don't know if you're following me before I proceed into today's discourse.
Yeah,
Yeah, thank you very much. I'm actually following. My name is Righteous Obea from Port Harcourt campus.
Oh, that's great. That's great. Welcome. Welcome. Right.
The last time.
You're welcome. So, thankfully, this class is very practical. So yesterday was to ginger you for the work. Today is the work. But because of the limited time that we have, I will just base today's class on two basic major drafts in property law and in criminal litigation. So I hope you have your notepad with you. Do you have your notepad with you?
Yes, we do. Yes, I do.
Okay, that's good. So I believe that by now you have been taught deeds in property law.
Yes, that's correct.
Yes. And you might have noticed when you are reading that deeds for the property law cuts across all the drafts you can ever see in property law. They have quite similar structure. Of course, content is different, but they are quite similar. So if you have a hang of how to draft deeds, I mean, the assignment for this class, you can take that knowledge into how you draft, be it your deed of mortgages, deed of lease, your power of attorney, even wills, because it has similar structure. Being that they all have their commencement, they have their education part, basically just stay a memory hub. So I'll just base this class on this. But that doesn't mean I'll not test you on those ones. But I'm doing it to make your life easier in your reading because yesterday I got a lot of questions about, oh, when I'm internalizing this, am I able to remember it? What do I do? So that's why I'm trying to like use this one as a base. So that if you understand this one very well, you can like transmit knowledge to your other deeds. Because most of the times in your bar finals, the examining part of drafting in property law, actually, or maybe the introductory part, the conclusion part, and then those operative clauses in between. So if you have a hang of this thing, no matter what they ask you, you're able to like get it. Because the truth is that as much as you might say you disagree, they will never ask you to draft a full mortgage because of want of time. But they can ask you for some clauses that you never like read, which is why you must be able to know what it is saying. So of course you can know you will know everything that it's saying. But by this class, you easily remember what you're reading. So that okay, if you see the similar points across all the drafts, okay, now okay, that one is good. Now let me on your own space, you now focus on the differences. You get, so it's faster for you to learn that way. You get, a typical example will be that in the power of attorney, you have an authority clause where you appoint the attorney. You get, but unlike that in the assignment, you're not really an authority clause per se. For the day of assignment, you probably have the fact that okay, this are going between A and this, and then you have the recital part, and then the bulk of the body. So you get, this just to like spell out the differences. You get, so I'll just quickly go into it. Already, I'm sure that you know what they did is it is a document, a written document that most times evidences conveyance. You have deed of assignment, you have deed of mortgage, you have deed of lease, you like name it, they have it for everything. There's even the wheels. So if at least it's even contract of sale, which also it has similar format also with this assignment of this draft. So basically just to your memory up. So maybe the thing that you need to know for deed is also that the deed has some common features. Just felt that it must be written and it must be signed, sealed, and delivered. Like you will see it in the part where signed, sealed, and delivered by so and so and so. Maybe by the within named assigner for an assignment, or within named vendor for a kind of sale, or a within named mortgage for the of mortgage. Basically, it just depends on what you are drafting. And also the fact that we have two major types of deeds. I don't know if you know it, so that maybe you can stock. Do you know the types of deeds that we have? Right, Ettenbach. Do you know the kind of deeds that we have? I should just keep flowing. Are you,
I don't understand. Please, can
the
you ask
types
again?
of deeds, the kinds of deeds that we have. the major parts of deeds. I already
Okay,
gave
by
it.
deeds
Yeah.
of deeds, you mean like okay, the major parts of deeds
No,
of a deed.
no, the types. The types.
Okay, is it like the deed poll, indenture?
Exactly. So what's a deed poll? The one that between.
A deed poll.
Yes.
A deed poll.
Okay,
Okay. You did already. That's it, Bob.
okay, all right, that's fine. So a deed poll basically is one to be signed by a single person, for instance, the power of attorney from
Yes.
one party.
Thank
Then
you.
a deed indenture requires two
Exactly.
signatures, like
Basically, it requires multiple parties. So sometimes you might even have a deed that's within three parties. And that's very common in mortgages. But anyway, just to give you an idea of the kinds of the types of deeds that you have. So when is a deed required? A deed is required where the state provides for you to have it like that. Where you're conveying interest in land, you require a deed. Where you're doing a lease that is exceeding 3 years, you require a deed. Over time, I'll give maybe towards your exam or towards your second half of your essayship, I will give you practical formulas because by then I'm sure that you'd have get a lot. But for now, I'll just give you as it is. So you also have where you want to use the power of attorney to execute a deed. For example, maybe you want to use the power of attorney to say, okay, give my land to somebody. That kind of thing, I need a deed. Or for voluntary surrender, basically, or for birth declaration. And then where don't you require a deed? Where just an assent. If somebody dies and you want to just give an assent, you may not require a deed. There is a vesting order where the court has already given an order. Of course, that order is insufficient. You don't need a deed for that. And then when it's a short-term lease, what I mean by short-term is that a lease that's below 3 years.
Less than 3 years.
Exactly. You know, what I just said now in your exams, both in your MCQs and your theory, these are things that they actually like ask. They actually ask you these things. They may say the deal is 3 years. And you're like, is it a tenancy now? Is it a proper lease? Don't be confused. You get. So when it's exceeding 3 years, know that okay, you use a deed compulsory. If it's 3 years and under, you know the answer, Abi. Mm-hmm.
Yes,
So
we do. But
yes,
can I quickly ask one question?
sure you can.
Okay. I read somewhere that if the power of attorney is to be executed by a company, that it must be by deed, by the provisions of Section 100 of Company and Allied Matters Act. But I was a bit confused while I was reading it. I don't know if you can like throw more light whether that's part of what actually required a deed.
Okay, so when I was asking about where deed is required, I said that when the statute provides it. So if you go through that comma, for example, and you see that okay, truly the comma requires a company now to execute a POA has to do it by deed automatically. You can only do that kind of agreement through a deed. But if it was in a case where there was no provision in the comma, I mean that maybe it's not required. So does that answer your question?
Yes, do. Thank you very
You're
much.
welcome. So to also tell you more examples of when you don't require a deed.
yeah.
A
Sorry, ma.
Okay, I'm listening.
Hello, ma.
I can hear you. I can hear you. I'm listening.
I do not actually think it's an obligation for companies to use a deed when executing a power of attorney, because it may or may not be by deed, right? So because the wording of that section just says that the company may use a deed to empower anyone. It didn't say when the company wants to execute a power of attorney, it must be by deed. So that's my opinion. Because I've seen certain instances where companies appoint people to do certain things with a power of attorney, and it's just a mere power of attorney and not a deed of power of attorney. So I think maybe it depends on the kind of transactions that is to be carried out. Like you said, if the power of attorney is going to empower somebody to do something, to use a deed in any of the transactions, like empower the attorney to use a deed in any of the transactions, definitely to be by a deed. But I don't think in every circumstance a company has to use a deed when they want to execute a power of attorney.
Okay, so maybe I'll just lend you both these cases. So you go and read more about it on when you can use POA. For I don't know, you may have seen it. Abina and Fahad, Shime and Shime, Powell and London Provincial Bank. So I feel like those cases will give you more it will give you more insight. But generally, the statute requires that you should do it. You must use a deed. Most times you might actually use a deed for power attorney. However, it's not exclusive. You get it's not exclusive, but most times you might require a deed. So just know the situation that requires you to use a deed and the one that doesn't require you to use a deed. But the general situation that requires you to use a deed is where the statute provides it. Where you are trying to convey an interest in land or where you are trying to rectify a deed. Another example is where you are transferring interest without constitution. Let's say a gift. You have to use a deed. Then where it leads exceeding 3 years. I already said that before. Then for attorney to execute a deed. You get. Then also for interest for surrender, written declaration. So that's basically like the general ideas where you require a deed. So where you might not require a deed most of the time is usually for an asset, a vesting order, that's a court order, a short-term lease, that's like one that's like a like tenancy, 3 years and under. Then for a receipt, that's not required to be under seal, of course. But of course, it means that it only means that if the it is required to be under seal, not by deed. You get. So just make sure that when you're answering our questions, you look at the question very well and say, okay, what is that agreement expecting you to do? Is it saying that I found interest in the land? So if we now go by this particular karma, because I don't have the section here, but if what you said is right, which fact that okay, it says may, so it just means that that act has given the company an option to either use a normal POA or one as by deed. So in the situation warrant that the company uses one as by deed, for example, where the company is trying to transfer interest in the land, it means that the company in that instance must execute a deed. But when the situation is just a normal one, maybe to say, okay, help me and do this, help me and do that, a normal PA must sufficient. So just make sure, the important thing is that take note of the ones of the provision very well. So usually where is something that the statute provides it, you get. Check out the circumstance that the statute actually provides. So now, if you don't forget to just go through that case I gave you before, Abina and Fahad, Powell, and London Provincial Bank, Shime and Shime, they will give you more idea of cases that require a POA. Do you understand? Are you following?
Please take the case again. Let me see. I know Shime versus Shime.
Okay, you know Shime and Shime. You know Abina and Fahad, Abina and Fahad. That is Farhat. When I say and, I mean fast also. Mm-hmm. So Shime and Shime, Abina and Fahad, Powell and London Provincial Bank. In this case, they give more elaborate examples of power attorney. You must check out this case to Ode and Unwara. These are local classical cases on power attorney. So did you get the case now? So I can proceed.
Yes, I know the Ude and Unwara.
Okay, that's good then. So I'll continue. Now I've told you what a deed is. I've told you the essential element of a deed. I've told you when the deed is required and when it's not required. Now, before I continue, this is what I'm saying are actually examinable areas. So if you're reading your book, don't just think that you're just reading for knowledge sake. Memorize it. Because they can either ask me your MCQ or they can ask you as an execution. They just put those inside the wordings. You get. So take note of it. And let me continue now. The essentials of a deed. Usually, as I said before, a deed always has a signature or the seal. So that's the part where you see signed, sealed, and delivered by so and so and so. You get, and then maybe the counsel. That I mean, that's the lawyer. Now attaches his stamp on that kind of thing. And then the delivery, where it's okay, say I've taken note of your, like it can be absolute question. For example, what I mean is that okay, you now I maybe the agreement is between me and Ettenbach. So Ettenbach is aware of interaction and I'm also aware. Or did we say that in the agreement that okay, on so and so happens, before it became aware. So those are things that you take note of in a deed. Delivery. And then attestation for an illiterate. For an illiterate, you know that an illiterate has to have in any deed at all. Nobody has to tell you that. And then if an illiterate is one executing a deed, they must be an illiterate jurat. I know that an illiterate is not someone that is unschooled. For example, if a Chinese man is executing an English contract in the literate law act, it may be viewed as what? Yes, not because he's not schooled now, but because they believe that by that agreement, he's not expected to understand what it is stating. Check out in certain illiterate jurat. Similarly for a blind person too. So once the question tell you blind person, don't go and be writing signed and that by Mr. Ewa Esenbok in the presence of blah blah blah. You probably fail the question because they asked for a blind person. So it just builds on you that you should what? Put an illiterate jurat on it. I mean an a blind person jurat. Also for corporate bodies, you know that corporate bodies you can do the general one or do the one where you use the common slot of the company where the director signs or director and secretary signs. So just know where it's mandatory and where it's not. Another important thing to notice is like if is the power of attorney for international transactions. This one generally, usually a notary public that executes it, I mean that attests to it. Maybe I said that you people sit in your exam, so just take note of it. So with this said, also the fact that you can engross a deed. This one they really ask in your MCQs. What I mean by engrossing of a deed, it means making copies. So I don't know if you're familiar with club that will tell you that okay, when you see a copy of a particular document, take it as original. You guess because to do some argument require that maybe you do that because like for example tenancy, where you have to give one to the landlord and another one to the tenant. In fact, most of them require engrossment, but not all. But you get so that those are things that you have to take note of at our institutions in a deed. And then there's governor's consent. But of course, you know that this one is not generally applicable. Usually applicable where you are transferring an interest maybe in land or property, mostly real estate. And then there's a franking. Franking is done by a legal practitioner. So with that said, I've tried taking you through the entire topic for deeds. What need for deed is the meaning of a deed, the features of a deed, which is in writing, signed and delivered, when it's required, when it's not required, the essential part of it, and now finally where our focus area is for today, the anatomy of a deed. That means the skeleton of a deed. Quickly, I'll tell you that a deed across board is divided into four parts. When I say across board, that means for deed of mortgage, for assignments, for power of attorney, for wills, every single draft you have in property law, they have four parts. That's the introductory part, the operative part, miscellaneous part, and concluding part. So sometimes when they ask you in the exam, they may just say that, oh, draft the introductory part of a deed of mortgage. What I expect to draft? Draft the part of mortgage. What I to draft? So when you already find out with the breakdowns, the in-between elements not that difficult to memorize. Even if you see it in mortgage, even if you see it in wills, even if you see it in assent, anywhere you see it, you'll be like, okay, the only difference is that okay, in a will, is by deceased giving to somebody. The person they give, okay, in a deed of mortgage, by the mortgagor giving so and so and so and so. Okay, in tenancy, it's about rent. So of course you might have a rent clause. Okay, in the assignment, there's no rent. It must just be a file of raising for consideration. Like this is something that if you know it already, no matter when they ask you to draft, you'll not feel so scared or so worried or so bothered. So this is just to help you to simplify the process. So now I'll pause my mic for you to tell me the anatomy of a deed. You are 3 years. So give me one by one. So you can leave me the last one. So tell me one anatomy of a deed.
Introductory part.
Thank you. The next person. Next person. Let me see
Okay,
and
the
getting book.
operative part.
Okay, that's good. One more person. Anatomy same.
I said the operative part, yes.
Okay. Is that something that was speaking or getting book? Okay.
It's Edinburgh.
Okay. Then let me see. Are you here?
Concluding part.
Yes, thank you very much. So, with that being said, what are the elements you find under an introductory part? Simple. In a day of assignment, generally, you have, I'll give my formula because that way it's easy to remember. But this particular formula might change depending on the agreement. But of course, for most of the deeds, they are essentially the same. It usually changes when it's for like power attorney or wills. So you can use this formula for all your deeds. Uh-huh. I believe you're taking notes. Now, for
Yes.
okay, now for introductory parts, you have for the deeds most of the times you have these four elements: commencement part, the date, parties, and reciter. So the formula is CDPR. Simple. If I ask you what commencement part of a deed, CDPR. You already know it like that. CDPR. What is C? Commencement. What is D? Date. What is P? Parties. What is R? Reciter. Already you know that in some deeds you may not be required to write reciter. Why? If you put is, it means you have to put a reciter. If you don't put is, you put reciter. Sometimes too, when you are drafting, okay, I want to put more information. That means invariably, logically, feel that put a reciter clause. But nonetheless, the part always has CDPR. In the part, it may just change with maybe the authority clause. So instead of CDPR, you have like CDRA, which means the commencement part, the date. Because you don't have part like that, you only have one person, the person. And then the R is like recital, and then A is like appointment clause, where they say, okay, I appoint Etimbok to be my true or lawful attorney. So you see that it's not that difficult. You see? So again, recap. Drug part is CDPR. C is what? Commencement. What commencement? This the attorney. Sorry, this is the assignment. This is the mortgage. This is of A. This is of B. This is of C. So in your exam, if they ask you to draft commencement part, don't go and start drafting the entire introductory part. Nobody send you. You're wasting your time. But if they ask you draft introductory part, it means you will draft CDPR. Don't go and think that no now. All a lot could be asking something this simple. My dear, they ask something simple. Give them the answer and move on. You get. So don't be caught up in that way where they tell you that, oh, ask write comment part.
Network actually logged me out. I stop at CDPR.
Yeah, we're still there.
Can you be kind?
We're still there. So like as I was saying, don't be caught in the web of someone that says they ask to draft comment part. You're not gonna draft the entire part. Nobody send you. What they ask you, give it to them. So I'm on to the next part, operative part. This is where you have your testatum, the capacity clause, your receipt clause, your consideration clause, word of grant, parcel clause. Maybe in a rent you have lease you have like addendum and co. So what's the formula for this one? TCRC WPH. TCRC WPH. What is T? Testatum. Note, because in your deed you have two similar wordings, testatum and testimonium. They always ask this thing in your taxation a lot. They will ask you, is testatum a part of the concluding part? And I'll be like, why is it testatum as testimonium? Which one? Know that the shorter one is the opposite part. The longer one is concluding part. What do I mean? Testatum is opposite part.
Concluding part.
Concluding no. Testatum is operative part. testimonium is concluding part. See that the longer it is, the downward it goes. So that in case they give you that time in your OBJ, you'll be confused. Automatically, that the statement is the one that always at the beginning, that's the opposite part. The one that's longer testimonium, which is a witness of which this did operate. That's the right testimonial, and that's towards the ending. But I'm just trying to say this so that you, in case they ask you in exam, you won't be confused. The statement is not a testimonium. The statement is basically now this is as follows. Shall in the beginning, Abi. So that's basically it. So let me come back to the opposite part. Formula is TCRTWPH. T stands for testatum. C is capacity clause or concession clause. There are two C's, sure. But so let me just use the first C as concession clause instead. Because most of the times the concession comes first. So what I mean is, in constitution of some of so and so and so, I give so and so basically. So that's constitution clause. That means what you are giving to confirm the agreement. I think everybody knows what an agreement is now. It's offer acceptance, it's consideration, basically. And then R is receipt clause, where you say, okay, be as the vendor, as the mortgagor, or as the mortgage or as the assigner. Oh, I acknowledge that I collected so and so contribution from person. It's actually very short. You write where the receipt of which the assigner acknowledges, receipt of which the mortgagor acknowledges. Very, very short and very succinct. And then you have your last one, which is capacity clause. Okay, are you giving out this thing as beneficial owner? Are you giving out as what? That's the question. Maybe are you giving out as a beneficiary? Maybe they would it to you. So basically, what power over all the property. And W is word of grant. Very simple. I assign, I transfer, I sell, I rent. Just what are you doing? Basically, in an assignment, of course, you use I assign. In a conveyance, you use I transfer. You get what I'm trying to say? Just know the right word of grant to use for the transaction they are doing. And then you have parcel clause. Parcel clause is basically the subject of your agreement. So in the name of assignment, typically you have maybe your land they are selling, or maybe you have your building. Same thing for a mortgage. Maybe you're mortgaging, you are giving out for mortgage your petroleum station. That's the end of your deed. You get typically that's what a parcel clause is. Is that they also write something about all that parcel of land. Yes, all that parcel of land. Like that so and so and so. You get that's what a parcel clause about. And then finally addendum. Usually like it mostly happens in maybe say a you see this amendment is also addendum. Addendum in the tenancy is usually like the rental clause. And the amendment is just the end part of your draft. So basically if you know these elements, opposite parts, you will not have issues. And most of the times, something that you ask you to draft. So learn they do this walk over if you don't know all these things. So in your mind, when you're trying to remember these things, if even if you're forgetting your draft, maybe you're drafting now and you're like, oh, I need to forget to put A and B and B. When you remember this formula, you know, okay, I've put C, I put CDPR, I've put CRC. Okay, I forgot to put W, or then put W. You get, so that's how to like memorize your draft across boards. So what's an example of the system? I said it before. Now this did witnesses as follows. What's capacity clause? You give this thing out as a beneficial owner. What constitution clause? In constitution of the sum of blah 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 blah. You get. What is receipt clause? Receipt of which, let's say, the assigner acknowledges. And then capacity clause, you give it out as beneficial owner. When you are trying your hands on professions, I'm sure that you will see this thing play out as realities. So after this class, I expect that everybody here go to their respective spaces, practice this thing, and let me know on the group chat. You can send it. I just want to know that you have taken your time to read it, so that when you're practicing, because you actually draft it now, so that you know that okay, what I'm teaching you today is in your mind, is cemented in your mind. So don't go and sleep about and teach you today. Go and practice it too, because as it's fresh like this now, it's easy if you to remember. If you go and sleep over it now, you might forget it. You get. So with that being said, I've taken you through the introductory part and operative part. What's the miscellaneous part? It's one that many people used to forget to realize. That's where you can something like maybe say option to renew clause. Everybody will be like, it's too long. They will not ask me. My dear, learn it to. I don't know I'm giving you a story, but learn it. I know in my set I was like, I think at that time I had learned everything in the draft, and I was like, this one they will not ask it. I think I did my exam. I was like, oh, I just learned this thing. I learned it, and that's exactly what come out of my exam. Just you can just imagine that I said that maybe it doesn't always come out because I have studied about so much that I did not see it there. No school they might just shock you and bring it out. See, it's better to be over prepared than being underprepared. So with that said, what are the elements of an miscellaneous part? We usually have the indemnity clause, you have the undertaking, you have the acknowledgement clause, you have the safe custody clause, and then you have what E. It's quite similar. That's similar. So let us do. So the formula is like IUASE. So the thing is that the only difference is that sometimes you may not be required to draft these ones, but in case they ask you, you know exactly what you're drafting. So the formula again is IUASE. I stands for indemnity clause. What's an example of indemnity clause? The assignee covenants to keep the assignee indemnified. I hear the word now, indemnified against all proceedings, costs, claims, and expenses. You get. It's a long one here, but I know that you see your example. Let me get them for you so that in case you don't have an example of it. The assignee covenants to keep the assignee indemnified against all proceedings, costs, claims, and expenses on account of any omission to payment. The assignee undertakes with the assignee for the safe custody of the original title deeds and acknowledges his right to the preparation of documents for inspection. As an example of indemnity clause. Said you means undertaking. Example is like most of the times U S and U A and S are the same thing. That is undertaking to be maybe to keep documents safe. As is what that's the S. Or that you acknowledge that okay, I'll keep document too, but if you're asking for it, I'll bring it back. So most time this clause are really like interwoven. So most of the times you end up drafting all for one. So an example, I don't know if you get what I'm saying. You get what I'm saying? If you're confident, me know. Do you get what I'm saying?
We are following you, ma.
Okay, that's good. I don't know that you're understanding it. If you're not getting confused, because I'm trying to make it as simple as possible so that you get the most of it. Because I said that miscellaneous clause formula is usually IUASE. I stands for indemnity clause, U stands for undertaking clause, A stands for acknowledgement clause, S stands for safe custody clause, and then E. So they're literally like interwoven. So an example of safe custody clause and maybe say acknowledgement clause is the vendor hereby acknowledges the right of the purchaser to call for the production. Yes, sorry. The vendor hereby acknowledges the right of the purchaser to call for the production of the original title deeds anytime the need arises and to undertake the safe custody documents. Are you hearing some familiar phrases like undertake, like safe custody, like acknowledges? So you can see that when I say that they're interwoven, I'm not saying it because I'm trying to confuse you. I'm saying it because most of the time this particular part, the course are always like interwoven. You get. So that's it for it. So you know that okay, if you very sometimes depending on what you are trying to draft, if you drafted like maybe say this particular, sometimes it covers the field for undertaking, for acknowledgement, for safe custody. So up until here, do you understand? And from right, do you understand? Right, do you understand?
Yeah, I understand. You know, at the time I was locked out, so I'm
Good.
trying to pick up from that operative part.
Yes. So, but this miscellaneous part, you understand it?
Yes, I do.
Okay, that's good. Book, do you understand it?
Yes, ma. I'm trying to understand. I think it's a bit mixed up in my head
Okay,
since
so
we
what's the
are
mix up?
drafting a deed generally. I was thinking we're going to like for the ones that some parts are kind of like not the same. I thought we were going to pick like maybe a deed of lease, a deed of assignment to say, okay, this is the one we are looking at. So, but then I'm following.
Okay, no problem. As long as you understand, I will now help you to spread it across the kinds of data that exist that has the assignment and all of it. So of course we're going to I know at the end of this class we're going to have like a mini practical session so that I can just like test out what you know. Probably just pick maybe a bit of assignment. So but the thing is once we are at that stage, I want all of you, because of course no the time can allow us to talk about all of these things. But I want to go in private spaces to go and learn so that one and give me feedback. Give me feedback. Oh, so let me quickly rush through the ending. Okay, some Rice, you raise up your hand.
Yes, please. I did not get the full meaning of E in that IUAS. I know I is for indemnity, U is for undertaking, A is for acknowledgement, then S is for safe custody.
And then maybe
But the E I didn't get.
encumbrance. It's, an example is like,
Okay.
yes, the vendor covenants to identify the purchaser against any anticipated loss or encumbrance. So it just depends on what you're trying
All
to
right. Thank
draft.
you.
You're welcome. So now let me just go to the concluding part, which is the like the last part of the deed. Before we now use a practical topic for it. So I feel like we're not going to finish what I've planned out for today, which is the fact that I wanted to go into charges. So maybe we would have to conduct another class soon. But maybe people will let me know when on the group chat so that we can have a class on charges. Or if that wouldn't work, if I should send a voice note, but I want a class so that I can know that you actually understand what I'm saying. So people will let me know. Maybe between this weekend, maybe last weekend this month and next, and maybe the first week in August, so that we can have one before people resume your class in full for charges.
Oh, okay, ma. I don't think. Okay, you mean charges in criminal
Yes,
litigation?
I'll supposed to teach it out today. But if we start practical
Okay,
class on this
all right.
one, we may not finish it. Because is this session is supposed to be like 2 hours. So and it's already like I've already spent 1 hour. So or except I can just rush through it, I don't know. But let me just see how far we can go. So lastly, for concluding part, you have let me tell you the formula. You have TSEACF. TSEACF. I like to call it TCCF, like C as in SEA. So I like calling it that, but anyway, you can call it your own end, you can call it TSEACF. Everyone helps to remember. So have you gotten that down?
I have.
Okay, that's good. So T means testimonial, that long one. It's usually like a witness of which these deeds you get. That's that part of your draft. A witness of which this deed has been executed has been executed on first is it first date I'm not remember it off my head, but you know that part of
Yeah,
your
a
draft.
witness of which the parties
Yes,
have executed the deed
exactly.
in
The
the
day
manner in the day and
first
yeah,
above
first above
written,
written.
exactly that particular part of the clause. So that's really testimonial. And then you have SEA. S means your TCC. That's your schedule. Sometimes you used to have schedule in your draft. Sometimes you don't have it. So when you have it, you can add the schedule part of it. Maybe, for example, you reference a document in your draft. You get. So in that kind of scenario, it means that you must put a schedule clause. If you don't have that kind of thing, it means you don't need the schedule clause. So for EA, I put them together because the execution part and the decision part are almost similar, but for emphasis, E is like where you write signed, sealed, and delivered by so and so and so. You get in the presence of blah 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 blah. So they're actually like together. So sometimes you might have it that for a blind person now, that test it might be that you use is blind person jurat. You get what I mean? That's why I put them together. So that one's the execution and the station part. So example is the common sale of these companies hereby are fixed below dash director dash secretary both sign. That's already executed execution part already. And then for a blind person, signed and delivered. After I know, I think the part where the for Judas where you said okay, I so and so and so, I cannot I've read this thing to this person. You get his name, a blind person, and he says that he understands it, and I am agrees with that kind of thing. That you can look at your note for the correct statement, but I'm just telling you the idea of it. So that's really how it is. And then C is your consent. That's governor's consent. Of course, you know that a deed of power of attorney does not transfer interest in land. You may not have a governor's consent because you don't require it. In a will, for example, you may not have that because you don't require consent. But for example, deed of assignment usually needs government consent, so that means you have to have it there. Deed of mortgage sometimes usually have it, so you need to have it there. A power of attorney that you're using to transfer land usually has that clause too. And then finally, franking. That's F. Franking is always prepared by Edinburgh, Olbatomisin Right ESQ of Edinburgh Street, Right Estate in Lagos State. Kind of thing. So typically now, with this said, I think I've taken you through the fundamental parts of a deed. I'll now run through it by formula. The doctrine part generally, you have CDPR, commencement date parties recital. Operative part, you have TCRCWPH. T is testatum, C is constitution clause, R is receipt clause, C is capacity clause, W is word of grant, P is passive clause, H is addendum. Then you have miscellaneous parts. I is indemnity clause, U is undertaking clause, A is acknowledgement clause, S is safe custody clause, E is encumbrance. And then you have concluding part. TCCF, that's TSCACF. So T is testimonium, S is schedule, E is execution clause, A is attestation clause, C is capacity clause, and F is franking. So with this, you have the general understanding of a deed. Now, why I took my time to explain it for you, because many times people get confused when they have to like memorize the drafting for the deed of assignment, deed of mortgage, deed of they always have in their mind that is fundamentally different. But why I did it like this, because I want to know that by structure, most of these drafts are not fundamentally different. So if you can understand the structure for a deed, you would have it easy peasy to draft any kind of deed that you have. Be it deed of assignment, deed of mortgage. Because most of the time the difference is only maybe in the commencement part and in their sub clauses in their operative part. You get, but fundamentally it's almost the same thing. In your exams also, they probably even ask you what I'm explaining. In that, oh, draft the commencement part of your mortgage. By effect, it means this is the mortgage. Okay, draft the commencement clause in the assignment. This is the assignment. So what's the difference there? You get what I'm saying? So if you know the structure, to memorize the entire other ones, it'll be easier. So I'm just teaching you so you can build on it. Of course, there are differences. You see that differences in the power attorney, like I said before, that okay, that one instead of CDPR, you have CDRA because of why. You know that because most times you don't have dual parties in the deed of power attorney. Okay, because you have appointment clause in the power attorney. You get, those are just like something that if you know the idea of the agreement, your mind just tells you that okay, it's true. In the about assignment, I'm not supposed to put appointment clause. Like you get I don't know if you get the idea of this base I'm trying to build. Do you? Do you?
Not really.
Okay, I'll come again. I'm saying that across board property law in property law, you I can't draft a deed. It can come in form of deed of assignment, deed of mortgage, deed of lease, tenancy agreement, contract of sale. There are many agreements you are trying to draft. But a level ground is that if you know the structure of a deed, it helps you in retaining the information on how to draft these deeds. Now, I used deed of assignment for example. Deed of assignment has the same structure, which is that it has the introductory part, it has complementary part, it has the secondary part, it has complementary part, and the elements are quite the same. Usually, the difference is usually like maybe in the commitment clause. Maybe in deed of assignment, you can say you write this deed of assignment. In deed of mortgage, of course, you cannot write deed of assignment because it's a mortgage that you have to draft. So what will you write in that kind of case? Deed of mortgage. But because you know the structure, when you have to draft, when you're trying to learn this draft, you will not be scared that oh, I just finished learning of assignments. How will I learn the mortgage? You get what I'm saying now? Because you already have a base you're working with. That, okay, most of these drafts they have similar structure. I think example is also is let me now go off what the it's in civil. Most of your motions fundamentally have the same structure. You write in the High Court of Lagos State, in the Lagos State Judicial Division, holding at Lagos State. Yes, you may if it's mission experte, you write mission experte in the title. If it's a mission by notice, by notice. But fundamentally, it has structure, which is that court title, suit number, the parties, and then the dated, the content, then the dated, and then who you are serving. But by structure, it has similar headings. The only thing that you now be required to pay more attention to is usually the content of it. When I'm asked to draft a petition, for example, in civil, that is, for example, a election petition, of course, the body is different from the body of a motion or notice. Now, do you get what I'm trying to say now? Do you get what I'm trying to say now? Do you?
Yes, I do.
Yeah, so the important thing now is to build that structure for so that you will not approach your reading or your drafting with fear. That's why I'm doing this thing for you. So that in your mind, you know that you have a structure, but that the extra effort you have to put is that you have to note the differences across these drafts. Be it of mortgage, be it of lease, be it power attorney. You get, but the fundamental structure, which is often examinable, you already know it. So that in exam, even if you don't know how to draft a deed of mortgage, but you know all the other subsections, you will not be shortchanged. Because if you have 5 questions in a sub questions in the question, and you only know like 5, but the last one that you don't know is the mortgage, but you know the structure, what will you just do? Give them the fundamental on and let the body for them. Of course, you will lose marks for it, but at least you will not lose the entire mark for not being able to draft at all. Now you get the picture again. So I'm teaching you this so that you can build on it in your private space, so that you can go and learn it very well. Those differences. Now you understand what I'm saying. Do we?
Yes, we do.
Perfect. So now we'll now use a live scenario of a deed to just highlight this formula I've been reading out to you. So it's not just the formula I'm teaching you. I'm teaching you in practice. That's what we're doing today. So let us use. Should we use a deed of assignment or should we use a power attorney? Thinking. Okay, let me just use a deed of assignment. So in deed of assignment, I don't know if you have anyone in your front, but I'll just read it out, and then you people will answer me by telling me the part of what I'm reading out. So I'll start. This deed of assignment is made this dash day of dash between 18 block of so and so street of the one part and right of so and so street, the assigner of other part. Now tell me which one is the introductory part. Tell me which one is the commitment clause, the date clause, the party clause, the just tell me what it is. So I've given you a structure already. So I expect you to highlight it for me.
Yes, ma. I think you just drafted the introductory part of the deed.
Yes,
So the
correct.
commencement is this deed of assignment. Then the date is made this dash day of dash. Then the parties, mentioning the names of the parties, their respective either assigner or assignee, and then the location, that's the address, is still part of the parties. Yes, and you did not include recital, so that's why I
Correct.
want to draft it.
Correct. Now you made one fundamental thing to my notice. You said is. When you add is, if I continue drafting and I omit a reciter, will I fail that question? Or will I pass? Will I lose some marks or will I get on the marks?
Yeah, from what you've been taught, if you do not intend to use recitals, you need to leave out is.
Good. So I'm happy that you understand the introductory part. So now I'll say something else now. And this will be for right. But of course, in space, if it's important, that means note it down. I'm just saying so that we can flow together. So okay, and that one. In consideration of the sum of 15 million naira, which the receipt of which the assigner acknowledges, he gives all that parcel of land located in so and so street and further described by a certificate of occupancy number blah 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 registered at blah at the land registry of Lagos State to hold onto the unexpired residue for blah 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 years. So right, what did I just finish reading? Which clause? What part of it? What did I read? I highlight it too. I'm waiting. I'm waiting, right? Okay, I think it's no more on this call. So, Thomason, can you hear me, Thomason? Thomason, can you hear me? I think Thomason is on this call. Book, I think you're the one that's here now. So, can you highlight what I just finished saying?
All right, ma. So I think you just drafted the operative part of the deed. So I heard that you drafted the test section, and you
Yes.
also drafted the consideration, and the receipt of that consideration, acknowledgement of receipt, and I don't know if any other thing was drafted.
Okay. So, what if you've said this one? What other things are left to be drafted? If you've read, I think that's something from that formula I gave you.
Okay, the receipt cost.
I mentioned the receipt
The
already. I
receipt
said
cost.
the as I know acknowledge the receipt. Now that I have mentioned that part, what part is left to be drafted?
The capacity of the
Yes. Give me an example
the
of that.
capacity of the assigner as beneficial owner,
Exactly.
right?
Good.
Yeah.
Then what other part is left to be added?
Word of grant.
Exactly. An example of that for the assignment.
Okay, the assigner assigns
Exactly. Then the next part that is left for this particular part of the deed.
the parcel clause and the appendant.
Exactly. So with this now, so that you have a very good idea of it. If you go and draft now, I feel like you can draft it off the top of your head. I believe. So I think I don't even have a question here now. I'll just give you so that people will not scope me, you know, practice. But if I don't, even if I don't, people should don't scam me. After you score, people must send me your draft to the group chat today. Don't do it tomorrow because I'll be busy tomorrow. I'll be back to work, but send it to me today. Anyway, so right, you missed the call. So I was asking about some part of the draft. So your turn now. Tell me what I'm reading.
Oh, sorry. The rain was actually.
It's all right.
It's raining over here, so.
Okay, sorry, it's all right. So I hope you can hear me so that I can start now. I'll read a
Yes,
bunch
please,
of
I can
things to
hear
you, then you tell me what I'm reading. In
Okay.
witness of which the parties have executed this agreement in a manner below the day and year above written, signed by the within named vendor in presence of name, occupation, address, signature, signed by the within name, assignee in presence of name, address, occupation, prepared by Edinburgh Wright of number 15, Thomason Street, Lagos. So tell me what I just finished reading, the parts of it and the end, each of the courses, and give me an example of give me what I said per line. I'm waiting.
Okay, I know it's the concluding part.
Okay.
And then you started with that sign, seal, and deliver is the execution clause.
Yes.
Then those other persons that actually wrote their name as witness is the attestation clause.
Yes.
And then we have the franking that's prepared by Kingdom Rights.
Yes.
That's it.
Perfect. So you missed one part of it. The what is what?
The consent.
Okay. And then what is in witness of which? What clause is that? Is it a statum?
That's the attestation.
No. Yeah, again. In witness of which the parties have executed the agreement in the manner below the year and the day and year first above written. Is that a statum? Is that testimonium? Is that execution clause? What is it?
That's testimonial.
Are you sure? It's not the statum.
Say again.
Actually, that it's not the statum. Are you sure?
Yes, it's testimonial.
Okay, so where do we to see which part of the deed do we have the statum clause?
Say again.
Which part of the deed do we have the statum clause?
Hello?
Which part of the deed do we have the statum clause? Yes.
The attestation clause.
The testatum clause. Testatum.
Okay, it's the concluding part.
Yeah, again, no. Which part do we have the testatum clause?
I only know that.
I'm tricking you. You got the first half of your answer very correctly, but I now wanted to trick you because of that. Do that. I told you that they to confuse people a lot with that question. Testatum, testimonial. So I want to know that you really know it. So which part of it do you have testatum clause?
Yes. Do we have the attestation or the
No,
testimonial?
testatum.
As the concluding part.
Okay, if you say that, where do you not have testimonial clause?
Okay, the testator. Sorry, the testator is not in the concluding part. Sorry, it's in the introductory part.
Is in the operative part.
The operative part.
Exactly. So this I'm just trying to just prepare you for exam. This is I used to ask questions. Though. You get?
I thought you were talking about.
No, it's fine. It's fine. I'm just trying to. No, it's fine. I'm just trying to just gauge your level of understanding so that now that you have answered that means you should that you know where it is. So that in exam, no matter they trick you, no good for anybody. If you know that the answer is correct, give them the right answer for them and drop it. Exactly. So I think with this, we can say that to a large extent we've covered the field for deed assignment. I don't know if I should now give you another one, but it's just that I don't want to go for concept of sake because of the many questions that it has. But even notwithstanding, I want you all in your private places to help me to draft deed of mortgage. And I'm saying it because people took it from deed of mortgage. So you will give me a draft of deed of mortgage and a draft for deed of lease. Because I know you put it from it. You give me a full draft. That's your assignment, though.
Can we give you a please? Because this mortgage, that's what we are really going to focus on first when we go back to school.
I know.
So I don't think it's not do us good to just cram it without.
Don't cram it. Just attempt it. But of course, you can focus more on the list. But attempt it.
Other people.
Attempt it because
but I don't even understand to attempt.
I get it. But just try. My own year is for you to try. Try it. That way, safe. It's in fact, I think if you do that, you give. Hmm? I think hello? I can hear you. Can you hear me?
Can you hear me, ma?
I can hear you.
Okay, please. I'm still having issues understanding. I'm still having issues understanding the formula for the operative part.
So the formula for operative part is TCRCWPH. TCRCWPH. T stands for testator. C stands for consideration.
I know that T is for testator.
Yes. Which means now these deeds witness as follows. That example what testator is now this deed witness as follows. Then for C capacity constitution clause in constitution of sum of blah 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 blah. Then this is R receipt clause. When you write the money finish, in brackets, the receipt of which the assigner acknowledges. That's our receipt clause. Then second C, capacity clause. The assigner as beneficial owner. Simple. Then W, word of grant. Assigns, finish. So let me now combine C, that's capacity clause and word of grant together. The assigner as beneficial owner, word of grant now, assigns. So that word assigns is the word of grant. Then TCRCW P is parcel clause. What is he assigning? All that parcel of land situate and lying at number so and so and so of Lagos State, carefully described in the C of O, labeled as blah 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 blah, and further next in the survey plan of blah blah blah, registered in land registry. Parcel clause. Sometimes it can be all that 3-bedroom flat. Get the idea now? So then H, addendum. To hold onto the unexpired residue. You get? Sometimes, like in mortgage, sometimes like in lease, you not have addendum. Although I didn't issue that one year, but of course when you're doing it, you know that. So that one is R. That one is addendum, which is the rent clause. That for you give him as rent for so and so period, maybe from July 1st to 2016 to June 30th of 2017. So with this, you better understand operative clause. Do you understand it better?
I do.
Yeah.
Yes,
so now, Etimbong writes, what am I saying? I don't want you to approach this assignment I'm giving for point of fear. The aim is not perfection, but once you try it and you give him feedback and I correct where it's necessary, when you go back to law school, it's like to be easier for you. So I think don't be scared to attempt it. I want people to try your hands on drafting an actual deed of mortgage. Just try it. For now, focus more on giving me these four structures. And on your own end, learn the inside clauses like operative clauses. I mean, like, sorry, option to renew clause for a lease and co and like that. You get? Because at the end of the day, those are what they ask in your exam. So don't be scared. Now that I'm telling you to do it, and I know that most of you are not ready new topics, I know. So I'm not doing it to embarrass you or anything. But I want you to try so that that fear will go. And then before you resume, you've gotten a higher step in. And who knows, it might actually force me to teach you something on mortgage so that you are far ahead of your mates when you resume. So just try hands on it and give me feedback. So do we have a deal now?
Yeah, we do.
Yes, we do. Thank you.
You're welcome.
We do.
You're welcome.
If the questions can be typed.
I think if people would help me with that because I don't have a question in my hand. One of you can okay, let me do it like this. Etienne, send me a question on Liz that asks you to draft on Liz. And then right, send me one that asks you to draft mortgage. Today, so that's all you can see. So if people will answer both of them. That's what I'll just do. So I'll just it's your question I used to gauge you. So anything you give me what we'll try together. So I think that's the bit we can do for today on party law. But don't be when you after today's session, I want to do another assignment. When you go back to read, especially your new topics a bit. If you have any difficulty, please let me know in the group chat so that we can talk about it before you resume.
Thank you.
Before you resume. So that the pressure will be lesser. Because I know when you resume now, they start bombarding people with plenty of work and then it increases. But if you can do it on the fallow land like you have right now before you resume, when you're going back to school now, it will just be like anything that's teaching you in the basically like revision for you. So just pick out maybe the thing that you think you will understand in the new topic, maybe one or two topics, and bring it per course. Let's talk about it exhaustively. For property, it might be mortgage, it might be wills. Those are the very bulky topics in property law. Let's try one on it privately. So that when you resume, you'll be fine. There's no how you want to do it that they will confuse someone because it should be like some minor additions, minor subtractions. That way you can have focus more on internalizing back to back and then back questions. So do you all get where I'm coming from?
Yes, ma'am.
Okay. You're welcome. So I don't know if we can still talk about any other thing under criminal today because I wanted us to talk about criminal charges. But we only have 25 minutes more. So I don't know how well we'll be able to cover the grounds. Should we do it today and stop where we can? Or do it on daddy? Guys, are you here?
I can hear you.
Yes, I'm asking that should we go into charges today and stop where the time allows us or fix it for another time? What should we do?
I think we can just end when it's time for us to end. Then we can always pick up.
Okay.
We can do the substantive part of it. Like just
Okay.
talking about the different and if we are fixing another meeting, then the other meeting will get more practical and get some scenario to try to see how.
So maybe what I just do right now is that I'll just do a very brief overview of what charge is about. And I'll go into the things like a table format that will send people to learn later on the parties, the charges, which one is charge, which one information. I know that's usually where people used to have problem with. Would that work? Would that work?
Certainly, wait.
Okay. So let me just go into it. I think by now you know what charges is, and you know how important it is in your buffer now. Every year, unfailingly, you have charges. in criminal. And of course, you know like 5 marks. So anyway, the content of the charge usually it has the heading in this court in the High Court of Lagos State in the jurisdiction. It's in the magistrate court, of course. You know that it's not High Court of Lagos State now. It will be in the let me say Lagos Magisterial District. You get so those differences. Then charge number for charge number. Note that in civil it is suit number. In criminal it is charge number. Then your parties. In criminal investigation, we usually have your prosecutor authority, and then defendant. Usually in criminal investigation, we usually have it as the state so many times. Because usually they're not against the state because of course it's a crime. And then the offender as defendant. Then preamble, depending on which place you are writing the charge for. So because it's not all charges that have preamble. And this one I'll explain further later. Then you have your main body. That's usually where you write your what do you call it now? There are two parts of that in your draft. The offense and that the statement of the offense and particulars. And then date and finally subscription. That means we signing it. You get. So another thing I should know in that draft is that with prosecutor authority in the High Court of Lagos, in the High Court generally, who is usually the prosecutor authority? Usually the state. In Lagos, the state of Lagos. So anytime you see a question in your finance say that draft a charge using Act of Lagos, don't just write the state. If you write the state, you'll miss the mark for that place. Write the state of Lagos. You get. Don't ever promote it. Now, if they ask you to draft for if they ask that who is prosecutor authority for a magistrate court, what will you write? Usually in the south and north, usually the commissioner of police. But in the FCT, for example, is the IGP. That's the General Police. You get. So and most of the times we usually special police for maybe say federal offenses. How I said that in the Abuja. Now for ADF, it's also a particular authority, and usually for federal matters, federal offenses. So that's where you have where the HA is a party. You in your parties you write the Federal Republic of Nigeria. But when it's not the AGF, maybe it's the AG of a state. You put the one that is according to. But usually AGF is usually Federal Republic of Nigeria. You get. And the states, usually the states. So where the AG delegates power to somebody else, you just put that AG's authority because no when AG delegates, it is deemed as though it is the AG that is still doing that charge. So you still put the same party as the Federal Government of Nigeria. So because the gave is power to the DSS, does not mean that you're not gonna write DSS deal. Federal Government of Nigeria. So with that said, you already know the major parts of this thing. So the rules of drafting a charge. We have 4 major rules. And most times I like to see about like a formula point because of how many times people used to mix it up. So we have this for major I divide into 2. The part that deals with a charge sheet, and then a part that deals with a count. I'm hoping that by now we know what is a charge sheet and know what is a count. But if we don't, I'll explain. A charge sheet is the entire body of document you're drafting. So if I ask you to draft a charge, that document you're drafting from beginning to the end, that includes the heading, charge number, parties, preamble, main body, date, subscription, everything. That's what you call charge sheet. And that's some specific ways that apply to them. But a count is usually that main body, aka statement of offense, particular of offense, as a count. So now the rules of drafting are in that order. There are two rules that apply for a charge sheet, and there are two rules that apply for a count. So that in your exam, when they ask you, you're not gonna misquote, because like I said, law school they don't technically to confuse you. But once you know this kind of things now, you'll not be confused. You will just ask yourself that, okay, what they're saying, is it as to the count or as to charge sheet? So if you can find that out automatically, if it's like question is asking for charge sheet, know that okay, you use only the particular two rules. If it's asking for count, you use particular two rules. So that you're not gonna mix the rules for charge sheet for count and vice versa. So now let me start. There are two major rules that apply to charge sheets. The rule against misjoinder of offenders, and then the rule against misjoinder of offenses. They're very similar, they're very easy to memorize. Then for count, you have the rules against duplicity and the rule against ambiguity. Is it making any sense? You can easily differentiate different between of them. So for the one that is for charge sheet, it's usually misjoinder of offenses or offenders. But for the one of count, it's usually the city people. That's duplicity, ambiguity. You get here. With that being said, what is the general rule? Well, let me first pause. Do you understand what I'm saying? Am I going too fast?
No, please, I don't understand. You said sorry, because you said there's a difference. The rule applies to rule against ambiguity applies to charges, and then you said rule against duplicity applies to count.
No, I
I'm
think
not really
you
sure I
misquoted
understood.
me.
No,
So
that's not question.
Oh, okay, that makes sense.
yes.
Let me get
So what I said
clarification.
was
Sorry.
that there are fundamentally four rules for drafting the charge. But to aid in memorization, I'm grouping it into two. The one that applies to a charge sheet, the one that applies to a count. So for the one that applies for a charge sheet, we have the misjoinders. Number one, misjoinder of offenses, misjoinder of offenders. As for what? Charge sheet. Charge sheet. Second part of it, the one that applies to the count. I call them the city boys. That's duplicity and ambiguity. Now you get up to that point.
Yes, I do.
Okay. So now for the one that has to charge sheet, that's what I want you to record by yourself.
The charge sheet is the rule against misjoinder of offender and against misjoinder of offenses.
Okay. Now which one is for count?
Why the count is duplicity and ambiguity.
Perfect. So that means you understand it. That's good. So now, just for know now the general rules and exceptions. A trick is that the only one that does not have exception is the rule against ambiguity. The rest they have general rule, they have exception. I've given you trick. So now let me go back to what I was talking about. I'll just run through this one. So you on your own, you're gonna get it finished. So for attack on the first rejoinder, for the rule against mutual offenders, we have general rule, which is that you're supposed to charge and try each party separately, even when the offense is committed jointly. Do you get it? But there are exceptions. Four exceptions. Number one, when two or more persons jointly commit an offense. This rule allows you to put them in the same charge sheet. Note, charge sheet, which means that I do not expect you to go and put them under the same count. But for example, now, Ewa and Wright committed theft. They were together as like co-thieves. By this rule, normally you should not be able to put them together on the same charge sheet. But this rule says that okay, because they did it together, instead of putting them on two different charge sheets, that okay, charge sheet A for Ewa, charge sheet B for Right, you can put them together on document, but under what different, like you can put them, don't let me complete it. You can put them under what the same charge sheet. You get it now? You get up to that point? So this one is saying that for offenders that committed the same offense in same line of action, you can put them together because they committed it at the same time. You can put them on one charge sheet. Normally, they said, okay, Ewa committed theft. So yeah, on paper A, write Ewa committed theft on that count A, count B, and count C, count D. But now say, okay, instead of putting different paper on paper A, you can put Ewa under our own unit under our own unit count too. And on that's same paper, can I put right on that is own unique count up until here. Do you understand? Do you understand?
Yes, I do.
Okay, perfect. So I'll go to the next one. Second section is that when two or more persons are accused of different offenses committed in the course of the same transaction. Now, what do I mean? Okay, today, Ewa and Right say that, my guy are fine now. I don't see say Mr. Lagoya, you don't come from abroad. Oh yeah, now maybe we go around for the house. He bring dollar come, he bring gold come. They can't go there. Oh yeah, when they are there in that house, they burgle it. That house, they kill the gate man. That house, they rape his wife. Maybe it is only maybe say Ewa that killed maybe they didn't agree to kill anybody, but Ewa killed the gate man. But they both stole the dollars and the gold. And also they did not agree to rape the man, but Right did it on his own. Now, normally, under this rule, you are meant to put each offender on his own separate charge sheet. But this rule says that no, because this particular offense says that we did it together at the same time. We did it when we were doing, like when we were trying to rob somebody. I did not go and come back. As I was robbing somebody, I was killing gate man. You were raping the wife. That person was, and then jointly we now what stole the money. And then finally, we had the same purpose of coming to our house to steal money. So, okay, instead of putting us on different charge sheets, put us on the same charge sheets on our unique count. Me, I rape somebody, we are separate. You kill somebody separate, but we both stole separate count. Do you get it? So the elements that you will now look for in this is that, okay, to know that, okay, how do I gauge when two people commit more two or more offenses under in the course of interaction? These three elements to follow. Number one, proximity of time and place. Now, okay, let me just read the other elements. Proximity of time and place, continuity of action, community of purpose. Now, what do I mean proximity of time and place? Me and you went to Mr. Mother's house to go and steal. The place that we went to go and steal is where? Mr. Lagaja's house. A particular day. Now, that element is established. The next one is continuity of action. As we were robbing somebody, I killed the gate man. As also, I raped the wife. But why were we here? To come and steal money. But then we committed an action, different actions, different offenses. So we can see that now the element of continuity of action also established. It's not that I stole money now and I went back home when me and Gata left the place and now came back and I raped wife. No, it was together. It was the same period that we did it together. You get it now. There's not like a pause, like a major pause. You get that element is now established. Then finally, community of purpose. When we were in our house planning this robbery, we both agreed that we want to go and rob the man. We had our minds in the same place. I did not follow Right to go and follow him and just accompany him. My mind was that I want to go and rob, or we want to go and rob. Let me use that word instead. So there was common intention of what we want to go and do in that place. So this further evidences what? Those three elements that were available. Proximity of time and place, continuity of action, common purpose. when either of these elements are not available, know that okay, this rule, this exception might not apply. And in that case, what will happen? It may mean that you cannot put them on the same chart sheet. Now, do you understand this, please? Or am I confusing you? Do you understand now?
It came a little bit confusing, but
so okay. What I'll do is I'll run down
the
again.
scenario you painted is a bit confusing.
Okay. What I'll do, I'll do it again. I'll read that exception again. It says when two or more persons are accused of different offenses committed in the course of same transaction. Me and right are accused. Right accused of stealing. Sorry, right accused of rape. Me is murder. In the course of a robbery. You understand now? Is it better?
Yes.
Exactly. So that is better now. So when two or more persons are accused of different offenses, you say that okay, you stole somebody's gold. Okay, we are going to steal dollars, but unknown to me, you apart from dollars, you now stole gold. So when they are putting a charge sheet, they will of course they will jointly say that we both stole money, but they cannot accuse me of gold because I did not like that three elements. I'm not want to still go with you. Only you stole gold. You get. So you get the point. So now, when two or more persons, so in that kind of transaction now, they will put all of you on the same charge sheet. For your joint offenses, they cannot decide that for those unique offenses, they not say okay, let us separate your accounts, different accounts. Okay, you stole gold, you stole, but everything shall on the same charge sheet. You get it? Do you get it now? You get it now?
Yes, I do.
Perfect.
I do.
18 buck. Thomason, do you understand?
Yes, I do.
Okay,
Yes,
thank
ma'am.
God.
Yes, ma'am.
Okay, that's good. So the third exception is that when a person is accused of committing an offense and another of abating, being an accessory, or attempting to commit an offense, they would both be lumped up in the same charge sheet. So, for example, me, I committed murder, but you help me to commit the murder. They put to us in the same charge sheet. Just that in my own, my own count to be that I committed murder. Your own count to be that you did at maybe aiding the murder. You get, but both of us will be on inside the same charge sheet, but under different counts. Do you get it? Do you get it?
Yeah, got it.
Okay, that's good. So finally, the last exception under the rule. Under the rule of okay, when a person is accused of any offense of theft, criminal misappropriation, criminal breach of trust, and another of receiving, retaining, or assisting in the disposal or consummation of that similar matter of offense, both of you be under the same charge sheet. I think that is very explanatory. So a recap of this particular rule is that generally the rule against the gender offenders provides that um generally Rita sorry, somebody's calling. Okay. Yes, generally provide okay. Generally provide that Ruth Ettenberg rights and Thomason should not be on the same charge sheet, the content offense. But there are exceptions. Number one, when some persons jointly commit an offense, they put them in that charge sheet. Number two, when two or more persons are accused of different offenses committed in the course of the same transaction. I know A and B are similar, but one is they committed jointly. Second one is no different offenses in the course of different transactions. So the third element is that the third exception is that when a person is accused of committing an offense of abetting, and the last one, when a person is accused of an offense of theft, blah blah blah. So that's basically it. This one is coming under what for charge sheet too. Now let me run through the other one, the second one for charge sheet. That's misgender of offenses. The same thing. General rule. Where a person, in quotes, a person now, where a person is accused of several offenses, normally you must charge him in different charge sheet. So if you're committing theft, put me on charge sheet A. I rape, charge sheet B. I kill, charge sheet C. Like plenty, but the law is like, why now? That's a lot of like you're just replicating same thing over and over and again. So we now gave exceptions. Number one, where a person is accused of committing several offenses all within 12 months, you can take 3 of offenses and put them in what? One charge sheet. Example, me now, in January, I burgled somebody's house. In February, I stole. In March, I, let's say, kidnapped. And that's how I kept committing offenses to December. When they now caught me, they now asked me, okay, how should this person offense now? She's a serial offender. She will not put out many charge sheets. Okay, I said, okay, no, just pick 3 of the offense and put on one charge sheet. So you can do that for the other offense, but on different offenses. So just pick 3 of the offense that I committed within 12 months and put them under one charge sheet. Do you understand this one? Do we understand?
Yes, yes. But my
Okay.
question is, why are you?
Why am I what?
Yes, I do. Why are we putting 3 out of the several offenses?
Because that was the law states.
Okay.
Simple. But
So
now,
the other ones will be charged.
yes. So this one now is that you have to note that for this particular exception, it does not apply in a note because there's no provision like that in the note. That's for people that are using CPCLO. If in ACGL Kano they have something like that already. In ACGL Lagos they have something like that already. But for in CPCL state they don't have it. So the next exception is that where the offense that I committed are so connected as to form part of the same transaction. Put them in the same charge sheet. So for example, I explained this in the last time. I said that there's something about proximity of time and place, continuity of action, continuity of purpose that applies here now. You know that first one was for offenders. That mean man and one person, but it was for someone that did many offenses. So now, if I set out to commit armed robbery, so because the person is annoying me now, I slap her. She now died. And before I slap her and she now died, I raped her. It was all at once. So they will charge me for both armed robbery, the rape, and the murder, all in the same charge sheet. But of course, separate counts, but in the same what? Charge sheet. You understand? You understand? Am I hearing anything? Do you understand?
Yes, ma'am. Yes, ma'am. We
Okay,
understand.
good. Then the third element is where the offense comprise same elements but are constituted under different laws. You will charge everything. So for example, if what I compared now, maybe say in the criminal law, they call it theft. In the Company Crime Act, for example, that's not existing, but just to try the point home, they call it shaking an offense. Okay. Then in the church act, they now call that same offense, they call it slapping. The law says that you would charge me for everything on the same charge sheet, because different laws say I did the same thing with different English, or what I committed, they are so similar that they are like now. Okay, I slap somebody under the law, in under church act say slap, under criminal law they say I steal, under company criminal they say it's shaking. So what will the lawyers do? Put everything for her in the same charge sheet. Sorry. Last, now she commit all the offense. Do we get that part? Do you get that part?
No, I don't.
Okay, so I'm saying that now. Let me just make it a more understandable one. In the north, for example, they may say that if you steal, they will call it theft. But in the south, they will call it stealing. So, but I'd mention that in Lagos, we now have separate laws that call the act of stealing. One call it theft, one call it stealing, one call it hijacking, one call it taking. But you know that everything is similar offenses, just that each law describe it differently. Do you get that part? The law is now saying that okay, this offense are quite similar, but just that each law define it differently. Now, barrow I take, but one law say na stealing, na say I steal barrow. Na still barrow I take, one law say I theft barrow, in quote. Na still barrow I still take, one law say I hijack barrow. Na still barrow I still take, one law say I take barrow. The same thing that they are saying, but different law provide for my offense. Do you get it now?
Yes.
So the law is saying
It's
that
clear.
you maple everything up in the same charge sheet for that person. So it's now for the court to decide which one that it will convict me for. You get? So most of the time, what the court does is that the court just convict you of one. Maybe they don't give the one that has the most severe offense, the most severe punishment.
Okay.
Yes,
Okay.
that's.
Okay, sir, I just want to ask for something.
Okay.
I just want to ask for a clarification. So for example, if it would be the same charge sheet but different counts, right?
Yes.
Okay. So you're going to charge the person separately for stealing
Yes.
in the south, and then for theft.
Yes.
Okay.
On all the acts that he violates, just keep charging him like that.
Okay.
So the law does not determine what to punish him for. So most of the times, those major offenses is that they also that they allow you to put different offenses in a charge sheet, but of course, usually under different counts, but the same charge sheet. That's the idea. So that you don't get confused. I'll be like, which one is not applying to count? I will explain. But for now, I think you get the idea, Abby.
Yes, I
Okay,
do.
so right, I said that you raised up your hand. What question do you have?
Yes, please. I just want to ask on a lighter note that how possible is it for someone, a particular person, to commit the offense of theft in the north, and then same person commit the offense of stealing in the south, and then the person will be charged on same charge street for different.
That's why I have to bring you back home. So I'm not expanding mind too much. Just like let's say, for example, maybe say Abuja. You know some laws in Abuja. If you commit this in Lagos, for example, they can apply in Abuja if they are prosecuting you.
Yes.
So that kind of place now, if Lagos calls my maybe the Lagos criminal law says it's stealing, but Abuja now call it theft. Because the dilemma of which one to prosecute you for. So the prosecutor now say, okay, let me just put him as in Lagos state law he committed theft, he committed stealing. Then in Abuja law where they caught him, he committed theft. So my lord, which one did he commit? Is it theft or stealing? You get, so court now prosecute you accordingly.
Oh, okay.
Yes. Another example is that some cases, in a particular jurisdiction, maybe even Lagos, for example, multiple laws might say that you committed many of offenses, but just that let me just use imaginary law. Law A says you stole. Okay, let me use a scenario like this. I talked about it before. In Lagos, let's assume that we have an anti-viral law in Lagos State. Same Lagos, we have an anti-ink law. Same Lagos, we have an anti-BIC law. And same Lagos, we have anti-pen law. But all of them say that don't take viral. If not, you have been said to commit blah 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 across board. If they not catch me, because at the end of the day, all these laws provide against taking somebody viral. If they catch me, there's too much law to prosecute me. So what the prosecutor just is that okay, my lord, all these laws apply to me, apply to the offender. My lord, I don't know which one you want to use in circumstance. So this is everything, my lord. This offers a comment on that different count. So my lord, which one should we hold him for? You get. Most times the law will say, okay, let's just pick one of the acts. Just like rape and sexual offenses. In some tradition, they won't call it rape, they will call it maybe sexual exploitation. So you get it, do you understand it better now? Even more.
Yes, I do.
Okay. Tomisi and Esenbok, do you also understand it very well?
Yes, I do. Thank you.
You're welcome.
Yes,
So
we
that's
understand.
okay, that's good. So I'll take to the final exception under the rule for misjoinder. Okay, I'll just give you 30 more minutes so that we can just round up the class. Yeah, for misjoinder of offenses, last exception is that where there is doubt as to which of the several offenses created by law may be established by the act that you committed. The law says that okay, oh, you can add it. I think this one it even cuts it. So now maybe I'm not even confused. Maybe say I raped somebody, maybe a child. And normally, juvenile law says that okay, if you rape a child, we'll call it rape. But in Lagos, there's a rape act that says once you rape somebody, you'll be said to have sexually hurt a person, or maybe say even rape the person self. But now there are now two laws that are applying to me. So I don't know which one to even use. So this election said that okay, charge that person in the same charge sheet on different counts on each of these law. So in that charge sheet, I saw something like that so person committed this effort of rape under the rape law. And that count that person committed some offense under the children law. You get the idea? So the duty for the court now said that okay, which one really applies to this person? And court on his own end will take into after that, okay, let's use the child home for him. Let's use general rape home for him. Do you get it? Do you get it? I'm not hearing your voices, so do you get it? Or you're confused?
Yes.
Okay, you get it. Okay. Now, let me now go for the clauses under count. So a brief overview is that I said there are 4 rules for governing charges. I group it into 2 divisions. One for charge sheet, one for count. On that charge sheet, we have misgender offenders, misgender offenses. I already explained. Now for count, where I'm going to, we have 2 also. We have the rule against duplicity and the rule against ambiguity. Now for the rule against duplicity, generally, every offense should be contained under a different count. Normally, you're not meant to mangle up rape, theft on the same count. You can't say A committed rape and stealing. No, now people separate it. A committed stealing, A committed rape. But this law Now says that I agree that normally every distinct offense should be under different count, but there are exceptions. What are these exceptions? There are also 4. Number 1, when there's a statutory exception. So some statutes provide that they permit joining of home offenses. Like now in Lagos, they will write burglary and stealing. Some even write housebreaking and stealing, or burglary and housebreaking. That means the law on its own already mangles up 2 offenses. In that case, if you write that offense like burglary and stealing, you will not have offended this rule because the law provides it like that. Do you understand? Do we
Yes, I
understand?
do.
Okay, good. The next exception, general deficiency of money over a period of time. So where a person is accused of maybe say breach of trust, criminal appropriation, money, stealing of money, fraudulent falsification of account, those kind of things, conversion. The law allows you to put the to like lump up his offenses under the same count. But note that that offense must be committed against the same person. So what I mean is that if I committed fraud, I committed stealing against only Tomisin, that's when this rule will apply. But against Tomisin and rights, no, I cannot use this rule again. Another time also is that, sorry, the date within which offense was admitted must be in the count. So if I said that okay, I did these offenses today, Sunday 18th, not today, Sunday 18th, then Sunday 19th. No, no. It will be the same day, did that same thing to the same person. And then the money that you stole or what you did, you must write it down in that particular account. So I take it again. For this exception, where a person is accused of breach of trust, criminal misappropriation of money, you can lump up the offense over a period of time. You can, but note that number 1, the offense must be committed against the same person. Number 2, the date within which the offense was committed must be in the account or must be in the account. The sum you stole must be in the account. And then if the money is money, if it's money, for example, the money must be in the same currency. But note, this does not apply to misappropriation of goods, only money. You get, or account, but not goods. Anything good doesn't apply. You get that one. So the last 2 exceptions under this rule is that identical offenses committed in the same transaction. This is sanitary. The law allows you to mangle them up under the same count. And finally, overt act of treason or treasonable felony. So the law allows you. So finally, last rule for count. That's the rule against ambiguity. Generally, the law requires that if you are writing a count, you must say it very well. Okay, let me take your question right before I continue. What do you have to ask?
Yes, please. From the rules you just mentioned, the exception to the rules against duplicity. Please, I didn't get the number 3 and number 3. I got the where it is statutorily provided.
Yes.
General deficiency of money over a period of time,
Yes.
and then overt act of treason or treasonable felony.
Yes, and the last one is.
But I didn't get the 4th one.
Identical offenses committed in the same transaction.
Okay.
Yes, you're welcome.
Thank you.
You're welcome. So the last rule is the rule against ambiguity. So generally, all this says that the charge must give the clear description of the law you violated, the offender, the place, the time, the division. So you cannot write a count now, and you not write the offense I committed. That count will be invalid because the offense is a rule against ambiguity. Or maybe you omit the place I committed the offense. So it also offend this rule, and this rule has no exception. So in bar finance, when you're writing your draft, make sure there's this ad pop rule you learn over time. Just like that, you know, okay, you must have it. I'll give you my table because that was how we start in this class. Is that you must not omit any of elements. It must mean that in your count you must have the offender. It's offense. The rule, you must have the offender. It's offense. The rule he violated, where he violated the offense, the place, the time. If you miss out any of these important elements, your count will be invalid for having violated the rule against ambiguity. Because if you tell me, my lord, Thomas is my name, Ewa committed murder, but there is no, you did not put the law. Which law says that he committed murder? You did not put it. How does my lord know that you're not fabricating the offense? That maybe it's not even existing at all. Or you say I committed an offense, you don't tell the law the place. Where did I commit the offense? Is it in Saboyaba? Or is it in Bari Abuja? Specific. So those things are like things that you must take note of. So, okay, right, you can ask the question.
Okay, you said there are three, but you must put the offender, you must put the rule he violated, and then where he violated the rule.
There are more than three actually, but I will teach you more about this when I'm giving you the actual draft. They call it ad pops. Actually, those are the elements you have to know. Ad pops is like it's like saying the maybe say the preamble, the act, the offense, the date, the place, the offense, the decision I violated. Basically, it's like 4 or 5 things that you have to just know. Okay, roughly, the offender is offense. Where committed the offense, the day committed the offense, the rule he violated. You get? So it's like 5 or 6 things. Do you get it now?
Yes, I got it. Thank you.
Okay. Thomas, raise your hand.
Yes, please. I don't really understand this rule of identical offenses committed in the same transaction.
Okay. Let me see if I can have an example for this. Identical offenses.
Is it also the same rule that says offenses defined in the alternative?
Yes.
Okay.
Do you have an example of that one so that I can be sure that we're saying the same thing?
Okay. I want to know that where there are alternative ways of committing an offense, isn't those different ways under one count to be allowed?
Yes, that's basically it. That's basically it. Because you just did the same thing. You did the same thing. Everybody did it, but you did the same thing.
Okay.
So, yeah.
Okay. Because I think that's the way they put it
In your campus. Okay, that's good. It's still the same thing we're talking about. You can just get up this case for that, for more information. Police and Oyewusi. It's not a very popular case. Maybe those 1960s, then you hear about this popular arm robber. So you can read about the case. Police and Oyewusi. You can read up the case to help you understand that rule better.
Thank you.
You're welcome. So I'll just rush through if you when you breach any of the rule in drafting, generally is not material, but where it will mislead the court and cause an error is material, and you know what that does, it can invalidate your charge. So, and then where that happens, that kind of charge now may be quashed on appeal, except you can show that it's not material. But where it is material, the court will just say, I beg, cancel that your charge sheet. You get that part. the other part. So let me just go to this one. If a charge is defective, you can talk about it at any time in a case before the plea. So before I say I'm guilty, I'm not guilty, you must tell the court that this charge is defective. But taking my plea now, you might have issues with that. So that's basically the rule. So where you convict a person on a defective charge. Okay. Okay, tell me sin. Then afterwards, right. You have the floor. I'm waiting for me. You have the floor.
Where is defective?
Yes, that's what the rule says. It says that you're supposed to object to the defective charge at commencement of trial before the plea. This does not mean that the court will not really your charge defective. That's why I went far to explain that if the court goes ahead on that defective charge and sees that the thing is material, they will just quash it. But if it's not, they may proceed with it. Material, for example, maybe you say somebody killed somebody and not kill somebody, and it was a mistake. The law will say, no, we cannot because of a mistake kill somebody now, or sorry, somebody of murder. So the court will quash that kind of defective charge. You can ask a question.
Okay. Because I actually experienced during my court externship, I actually experienced it where somebody was charged for possession of firearm, kidnapping, armed robbery, and the rest of it. So after the defendants, both of them took their plea, the prosecution team now made an application, though they filed it before they took their plea, that they have new information and they would like to amend their charges, and it's likely possible that most of the offenses charged will be dropped. So I don't know. Though I asked my lord, and she said yes, provided they are filed, and that there's actually difference between what is practically obtainable in the court and what is on the paper, like theory.
Okay. So be it as it may, just make that for your exam purpose, you have to just stick with the rules, at least for now. So I guess that one, the probably drop is offense because maybe when they are posting a trial, so that okay, maybe there's probably not enough evidence to show that it commits some particular offenses. So just take it off. I guess that probably what happened in that particular case. So going further,
Thank you.
you're welcome. Amendment of a charge. So when you make a mistake in a charge, how do you correct it? You can do it at any time before judgment. And you simply do it by either framing a new charge, amending it, adding or altering it. But do everything before judgment. And who can do that? The person that drafted it. So if it's for example, maybe the law officer, the magistrate, the one who shall the charge, that's who can amend it. Now, this one was very common as a sub question under charges, the procedure for amendment. There's 3 phases before arraignment. There's that one for and there's another one about post amendment procedure. But that was very, very common in exam. I'll teach you 2 of them because they come out either way. Any of them can come out. So for amendment, if you want to amend a charge before you take your plea, as before I say I'm guilty, you can do it without leave of court. That means just because of course you know the court has not really done anything. But when they've already said, oh, you are guilty, you're not guilty, you might have to ask the court for leave that, oh my lord, I noticed there's an error on my charge sheet and then I want us to correct it. However, there's also an exception for this. If you are amending your plea, if you are amending your charge before a plea is taken, in the ACJ Lagos, they say that you should ask for leave. That's the difference. And then let me now go to Let me just say that fact that let me just go, okay, if you now want to amend your plea, your charge, sorry, your charge after arraignment, that means that's say somebody is guilty and then the court will go on trial. You can only do that with the leave of court. That means ask court permission before you can. So the summary is that if you want to amend, if you're amending before plea, you can do it with that leave of court. But in ACGA Lagos, it says you have to ask for leave of court. Now, if the plea has been taken, the former of the charge is at liberty to amend the charge where defect is noticed yet, and then oral application suffice. So, I think that's basically it for. And then I said that after arraignment, you would have to ask for the leave of court. After arraignment. Okay, what do you want to ask? Right.
Okay, please. Sorry. At this point,
Okay.
please. You said when you're talking about amendment procedure, there are two stages of so. You said the post amendment and the
No.
Post amendment procedure.
No, I meant
that's before the plea.
No. That was a mix up. I meant before arraignment and after arraignment. Sorry.
Okay.
Before arraignment.
Right.
So before arraignment, before you take the plea and after I take the plea. So before you take the plea, generally they will say you should not ask for leave. But in some courts, they may tell you to ask for leave, like in ACGA Lagos. But in Kano now, for example, they only ask for leave if you've done it after arraignment. You get after taking your plea. So, but the second part of it is that before arraignment, when you're taking your plea, most times you can just amend it through oral application. So for the after arraignment, which is I've said I'm guilty, the court is already contesting trial. Most times you have to actually ask for relief of court. Now, to the mix up which is post amendment procedure that mostly always comes out. They are like this one should memorize it, sha. They're like, let me just say roughly 5 procedures that you must know. So I'll say it as a story format so that I can understand that first of all, I have a defective charge. I want to amend it. I've amended it already. Now what do I do so that we can what do I do after that? Number 1, that new charge that I've already amended will now be read to defendant in the language that you understand. Number 1. Again, that new charge will be read to and explained to defendant in the language that he understands to the satisfaction of the court. Number 2, that defendant must now enter a fresh plea. That okay, I'm guilty, I'm not guilty. So that plea I took before in the first charge are defective will not be applicable again. So let's take a new plea that okay, now I'm guilty for the particular charge that you have done. So again, number 1, the new charge is read and explained to the defendant in the language that you understand to the satisfaction of the court. Number 2, defendant is to enter a fresh plea on the charge by himself or personal, not to his lawyer, by himself. Number 3, when he has done that, the defendant now has the right to adjourn the case if he needs it. Maybe it's that okay, now I have to go and read the new charge at any time because he has the right to ask for adjournment. Number 4, that same defendant or prosecution, depending on who it is, also has the right to recall witnesses. So the fact that he has already called all the witnesses in the last chat that was effective does not mean that you will not say he cannot do it again because as it is, that defective has already been quashed. So this new one has to take over again now. So he can now call witnesses again. So again, I said from the beginning, number 1, after I've made my charge, first thing that will happen is that new charge must be read and explained to the defendant. Number 2, sorry, in the language he understands and of court. Number 2, the defendant must enter a fresh plea on the amended charge. Number 3, by himself personally. Number 3, the defendant or prosecution has the right to adjourn if need be. Number 4, defendant or prosecution also has the right to call witness or recall witnesses. And finally, the court must endorse order of amendment on the new charge. That means that okay, this charge was amended today, the dash day of dash, signed, name, chief judge, chief magistrate, depending on what it is. So do we understand this post amendment procedure?
No, please, if you can be kind enough to take it again gradually, but this time it seems you are fast because your time is up.
No problem, but do you understand the concept before I go back? So I know that I'm going back to just read it for you.
Yes.
Understand it? Okay.
Yes, I do. You're talking about the post-arraignment procedure.
Post-amendment. Yes. So first of all, I said that the new charge is read and explained to the defendant in the language that he understands and to the court's satisfaction. Have you written that down? I've written that down. The new charge is read and explained to the defendant in the language he understands and to the court's satisfaction. Have you written that? The
network is kind of breaking.
Okay. I'll take it one last time. The new charge is read and explained to the defendant in the language he understands and to the court's satisfaction. Have you written that?
Yes.
Number 2, defendant is to enter a fresh plea on amended charge personally and not through his counsel. Defendant is to enter fresh plea on amended charge personally.
Katra Mum Michael Mum Janet Shaw.
Have you gotten that bit?
Yes,
okay, defendant is to enter fresh plea on amended charge personally and not through his counsel. Number 3, defendant and prosecution are given the right of adjournment if needed.
Yes,
Number 4, defendant and prosecution are given the right to recall or call witnesses. And then finally, the court is to endorse order of amendment on the new charge.
Okay.
So a sample of that is that this charge is very simple. You can ask to draft in your exam. This charge was amended today. Dash of dash. Sign it, your name and your position. That's all. Very simple. So I wanted to ask before I finish to this class. Have you been taught charges in school, in class?
Yes, we have.
Okay.
That was week 8 and week 9.
Okay. Was that the week you left for attachment?
Yeah. Yes. Week 9 we did rules of drafting. Yes.
Okay. That means with this class now, I'm sure that you know how issues with drafting. You just want to start like practice out of draft.
Yes.
Okay, that's good. So I will end by saying that the effect of failure to follow this post-amendment procedure. So you need these 4-5 steps. If you don't follow it, it can render a trial a nullity and vitiate the entire proceedings. Because will be like, I trying to miscarry justice. You get that's basically the effect. So it is a very, very important procedure when you amend a charge. So on this note, I think I've covered the field for charges. What's left for us to now cover is the actual drafting of that charge. So I will take a picture of my notes, just the table part of it, that has for you to know if asked to draft, maybe in the magistrate of note, you know that what they mean is that, oh, that draft a charge, or draft an information, or draft a charge by FIR. So that table just give us. It may not be very instructing, but just stop the table pending our next class. But however, that doesn't stop you from attempting your draft though, on charges, because that's what we're left with. You get. So I think we've covered the field a lot today for criminal law and property law. So
Yes, we have. Thank you so much.
you're welcome. You're welcome. So
Thank you very much. Yeah, grateful.
you're welcome. So your own part of the bargain is to give me an assignment, like I told you before, on the mortgage and leases, your drafts, and then another one on charges. So that's what you owe me now. Oh. If you don't give me that one, I'll be disappointed. So I'm expecting that from you. You can leave it on the group chat. Let me just put a disclaimer because of I'm very busy, so sometimes my work might come late, but I will actually respond to you. So those don't be offended in advance. Should in case I respond late. So thank you for joining today's series. In fact, this is the second part of this series. So thank you for joining. If you are not around today, but thank you for joining this series, and we are happy that you've been able to gain one or two things, and we hope that you put these things you've learned into good use by actually practicing. You know draft by practicing draft. You don't know draft by just what I explained to you. If you don't practice, you forget it. So from today, practice, 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 till it becomes like a memory verse in your mind that you can be saying it everywhere and anywhere.
Okay.
So that was you owe me. So thank you for today. I think with this we
God
can come
bless
to
you.
the end of today's series. Yeah.
Thank you.
Look forward to your assignments. You're welcome. Look forward to your assignments. Have a wonderful evening and enjoy the rest of your
And you
weekend.
too.
That's that.
You too.
You're welcome.